This video is going to be a quick tutorial of how to actually fill in the C100 application form to apply to court for an order. This is a form that pertains to the Children's Act of 1989, so this is most things that you might want to request the court to make an order about to do with your children. So if you don't have a solicitor, that's okay. We're hopefully going to give you all of the advice that you need to complete this without the use of a solicitor. If you still find that it's a bit daunting, you can contact us, you could ask friends or family, you could maybe go on an online forum and just have a look around for any more advice that you could possibly get. When you finish filling this form out, we really recommend that you get a second opinion about the things that you've written down, just to make sure that you're not being maybe too emotive about what you've written, and you just need to make sure that it's really nice and clear and concise, and that you're simply telling the court exactly what it is that you want, because the simpler the better really when it comes to this form. So without further ado, let's continue. So the first page on this form is to do with a mediation meeting. Now everybody who makes a C100 application to the court now has to do a mediation meeting, although there are some exceptions. So you'll see the exceptions if you have a look in the leaflet that comes with this form. But most of the time you'll probably find that you're asked to attend mediation. So this form, this page of the form is just making sure that you understand that. So you need to read the statements below in this declaration. There's just stating that you're not going to be able to move forward in the proceedings until you've actually attended a MIAM, unless of course you are part of, listed on the exemptions for your specific case, and then in which case you won't need to attend a MIAM, but you just need to sign and date, just to make sure that the court knows that you've read that and you understand. And that's that section, nice and easy. This section is just basic details about the case, so where it says to be completed by the court is obviously to be completed by the court, you don't need to worry about that part. Full name of the applicants, that's your name. Name of the respondents is the person or people who you're taking to court. Then you'll need to fill out the nature of the application, so are you asking for a child arrangements order, prohibited steps order, specific issues order. You will then need to put very, very basic description of what you're asking for, so a CAO to ask the court to clearly define an order for contact, or a PSO to prevent my ex-partner from moving out of the country with the children. You get the idea. Concerns about risk of harm. Risk of harm is a very sensitive area because you're technically making an allegation if you're going to be ticking yes on any of these boxes, so make sure that you're absolutely certain that you have grounds to make these allegations. It will be investigated, it's not going to do you any favours if you lie, and it's certainly not going to make the case go any faster if you make a false allegation. Make sure that you have grounds to make the allegation, and if you're going to tick yes to any of those boxes, make sure that you fill in the form C1A and file it along with this one. Additional information, that part's self-explanatory. Make sure that you tick the appropriate box, and just take note of the instructions that it says next to the yes and no boxes, so that you know which sections you need to fill in for the box that you ticked. Section 1's nice and easy. You just need to put in the details of the child or children who are going to be the subject of this case. So if it's just one child, you just put one child in there. More children, fill them all in. Make sure that you put in details of the relevant orders that you're applying for each child, and your relationship to the child and the respondent's relationship to the child. Nice and simple, that's that section completed. In section 1A, you just need to notify the court of whether or not the children are known to social services, and if so, just put details in. Child protection plan, again, that's to do with social services. You need to put details of whether all the children have the same parents, if there are multiple children listed in the application, and then you'll need to put details down of who the parents are and who has parental responsibility for each of the children. You'll also need to put details of who the children live with, so whether they live with you or the respondent, or they may live with friends or family, so you'll just need to put details down there of where exactly the children live. If you don't want your ex-partner to know where you and your children live, you don't have to put that information in that box. You can always fill out form C8. Section 2 is just to determine whether or not you need to attend mediation, so it's quite a self-explanatory section. Make sure that you take note of the phrases that are in bold, and just follow the instructions on this form. If you've already attended a meeting for mediation, then that's nice and straightforward because you can just tick that yes box. Other than that, make sure that you fill out the relevant section here. Section 3, you may not need to fill out. If you have already completed a mediation meeting and you've had the form signed, you don't have to do this part. If you are saying that you are exempt from attending mediation, then this is your opportunity to tell the court why. Make sure that you fill in the relevant section, tick the right box, just so that the court is aware of exactly why you don't need to attend the mediation meeting. You don't fill out section 4. Section 4 is for the mediator who you see when you attend your MIAM. So if you have attended that meeting, make sure that you pay the extra fee, or make sure that your mediator remembers to fill in this form. I think it cost us about £40 to have this form filled in, so just for one page to be signed and stamped by a mediator, that's quite a lot of money. You're going to want to make a copy of it. Make sure you photocopy it, you keep the original, scan it in too, and then that way you don't have to go through the procedure of paying somebody just to fill out that one page again. The court will accept a photocopy. You don't have to have the mediator sign multiple sheets. They will charge you every time. Just make sure that you have it signed once. You keep hold of it, keep it tidy, keep it somewhere safe, because that's your proof that you've attended mediation, and then the proceedings will be able to move forward. Section 5 is where things get wordy. This is where you're going to have to explain to the court what you're asking for, why, what you want them to do. Make sure that you're very, very clear, concise, to the point. You don't want to be waffling. Don't go over onto multiple pages. You don't have to tell them your life story, your history of your relationship, how your relationship is with your children or your father or whatever. You don't have to do all of that. All you have to do is just fill in the boxes as short and sweet as you can possibly do it, but just make sure that you get the very, very basic details in there. So if you need permission to apply to court, why is that? Are you a grandparent? Are you a step-parent? Make sure that you fill that in if necessary. You might not need permission because you may just be the parent, in which case Section 5A will not apply to you. Section 5B, again, make sure it's short and sweet, nice and simple. So you'll need to say things like, have you seen your children in the past? If so, what was the previous arrangement for contact? And then why have you had to go to court? Has communication broken down between you and your ex-partner? How, why? As very, very simply as you possibly can. You just need to give these details, and then what you want the court to do. Do you want them to define an order so that you have regular and reliable contact with your children? Do you need a prohibited steps order? Do you need a specifics issue order? Just make sure that you put down the details as simply as possible. I've said that enough times now, you know what I mean. Section 5C, if you prepared a parenting plan. Now, a parenting plan is not necessary. You don't have to do one, but you may be asked to as things proceed. Don't worry too much. If you had a go at completing one, fine. Make a copy, attach it to the form, but it's really not necessary. Just tick yes or no there, and that's section 5 complete. Section 6 is only for people who take that they want an urgent or without notice hearing. You might want an urgent hearing because your ex-partner wants to take the children on holiday and you've said no, but they're just going to do it anyway. So if you don't think that it's appropriate for them to be taking the children on holiday, you can make an urgent order or request an urgent order for the court to prevent that from happening. If you want a without notice hearing, that's explained a bit further down, but without notice hearing, it may not be necessarily urgent, but you may not want the respondent to know that you're applying to court, because applying to court may potentially put your child at risk of harm. Say if your ex-partner has said that they'll abscond if you take them to court, for example, or if you think that the child is at risk of being abused or anything like that, that's when you might need it without notice hearing. So again, clear, concise. You just need to explain the order that you're seeking, which is urgent or without notice, and you need to explain why you're applying to that order, and the reason why you think it's urgent. In addition, if you want to make a very urgent hearing, you have to still give your ex-partner notice that you're going to do that. So if you want an application within 48 hours, for example, you would have to fill out this box here just to tell the court that you have actually already made your ex-partner aware that they are going to potentially be going to court. If it's any longer than 48 hours, the court usually serve the papers on your ex-partner and on you, well, on the respondent and on you themselves, so they'll just send it out in the normal post, in which case they don't need to know whether you've already tried to notify your ex-partner, because they're just going to do it. But you'll still get an urgent hearing. It'll probably be within a week or two. And that's that section complete. If the child or children involved in this application have already been part of a previous court case, then you will need to fill out section 7. So if it is the case, you should already have all of those details there. So you should already know the CAFCAS details, the date and the year, the name of the court, the name of the children, case reference number, things like that. Just make sure that you include what the orders were for, and then attach any copies of the orders too. This is another very self-explanatory section of this form. Section 8, it's just to do with international elements, so it might apply to you if you or your partner aren't a permanent resident of the UK, for example. You would then need to fill out this section. If it doesn't apply to you, just leave it. Make sure that you fill out section 9 if there are any details of anything that might affect the ability to participate in proceedings. So it may not apply to you, it might do. If it applies, just fill it in. If it doesn't, just skip it. Section 10 gives you the opportunity to let the court know if there's any specific needs or requirements that you might need, for example, a translator. So make sure you just fill it in. Tick no if you don't need any of the things that it's asking you if you need. Obviously tick yes and provide further information if you do need the additional help when you do attend courts. And remember that there is a section there as well for children, so if there are any children who have special needs and they need to attend court, then you can also fill that section in too. This section's nice and straightforward because hopefully you'll know your own details, but this just gives you the opportunity to provide more details for yourself so the court can contact you about the hearings. So just make sure that you fill in that section as accurately as possible, and then you can just move on. Section 12 may be really easy or really difficult. If you know all the details for the respondents, then you can just fill that section in. If you don't know the details for the respondent, don't worry too much. You can just tick don't know. If you don't know the location of your ex, say for example they've moved out of the area and haven't given you an address, then you can fill in a separate form called a C4, and then that will instruct the court to order certain people to tell the court where the respondent is. That's not necessarily going to mean that you get the details of where the respondent is, but the court will have that information, so then it can move forward because you'll be able to contact the court will be able to contact the respondents, and then the case can move forward. If the child or children live with a guardian, then you may need to complete section 13. This just basically gives you the chance to name other people who might need to be given notice of your application to court. It probably isn't relevant, but if it is, just go ahead and fill that information in. Again, you've got the option to tick don't know if you don't know where they live or you don't know certain details about them, but just fill in that section again as accurately as you can. If you were appointing a solicitor, or if you could afford to appoint a solicitor, you probably wouldn't be here watching this video. So I'm going to assume that you don't have a solicitor acting for you. So if you don't, all you have to do is just tick no in this section, do you have a solicitor acting for you, and then you can just move on. Obviously, if you do have a solicitor, just fill in the details about your solicitor. It's as simple as that. You are allowed to represent yourself. If you don't fill in solicitor's details and say that you don't have one acting for you, then the court will just basically list you as being a litigant in person, which is perfectly fine and allowed. I'm just going to put these two sections together because they're so short and simple. So the checklist is just to make sure that you've done everything that you need to do. Just tick them all off, just check through your form, make sure that you've got all of your details filled in. The statement of truth. If I were you, I'd complete that part in pen. If you don't have a solicitor, ignore the name of the applicant's solicitor's firm and ignore the position or office held. You sign it where it says applicant and then applicant solicitor. You just sign that section there if you are indeed representing yourself. And then what you need to do is make 4 copies. If there's only you as the applicant and there's only one other person as the respondent, you need to make 4 copies. Those copies are for the respondent, for the applicant, for CAFCAS and for the court. Once you've done this, you'll need to contact your nearest court, get the details from them of how they want you to submit your application. You will need a fee of £215 because that is how much it costs to file this form. If you are on a low income, you may need to fill an additional form out because you may be entitled to help with all or most of the fee for this form. So just check before you do go and pay, just to make sure that you don't fall into the category of not having to pay. Apart from that, that's this form completed, and all that's left to say is good luck with your application, and I hope that you get the right outcome for your children.